Hello, my name is Randall Borden. Welcome to my legal podcast. I have on with me as a guest today Patrick Siewert, and he is a forensic analyst with 25 years experience. Welcome and thank you for coming on the show.
Thanks, Randall. I appreciate the opportunity. I always like the opportunity to talk to any litigators in the space that we can try to connect and see where our services can coincide with yours.
I have a lot of questions for you. You have a great resume here. We got it. Can you tell me how do you get evidence from someone's telephone into the court? How do you
Sure.
transform it from, I guess, the chain of custody, starting with the phone, with the video game, with the computer hard drive, and then transferring it over into admissible evidence?
The first thing that we have to consider is legal access to the device or devices. And that can come, generally speaking, in most cases, especially in the civil realm, it comes from provided by our client. So essentially through consent. In some cases, it is not provided through consent. It's provided through a court order, issued by the court that says the opposing party needs to provide not only their device or devices, but also the access to those devices. So once we get the legal access part squared away, then we acquire the evidence. So how do we do that? First of all, we document the evidence. We document the chain of custody. We document who gave it to us and when and where and at what time and what the evidence was, right? So we have to say there's an Apple iPhone 15 with this serial number and log that and have them sign the chain of custody to us. From that point, depending on the type of evidence that it is, whether it's a phone or a computer or some other standalone type device, we have a number of different techniques in order to acquire that evidence. So let's talk about a phone, right? With a phone, we generally use a tool called Celebrite, which is a very popular, widely used both in and out of law enforcement, a mobile forensics acquisition and analysis tool. And so we'll essentially connect the phone to a computer that's running this program, Celebrite, and tell it the types of collections we want it to do. So in most cases, with most phones, there's more than one collection type available. And iPhones are pretty well standard across the board for the most part. But when we get into Androids, we talk about different architecture of Android phones. So if you have a Samsung or an LG, where they store certain things may be different depending on those manufacturers. And so we may have to do more than one type of acquisition. So we look at the type of evidence that's being sought. We generally, as a rule of thumb, try to get everything that the phone, I like to say that the phone will let us have. Because in the modern era, there's a lot of security on mobile devices. So it used to be a long time ago, you could get everything soup to nuts from bit zero to the last bit. You can't really do that anymore because of modern security on phones. You can sometimes often do it on computers, but on phones, it's a little bit different. So we get as much data as the phone will let us have. And clients sometimes don't like that because they'll sometimes say, well, you're just after my text messages. Why can't you just get the text message? And the answer is, well, most of the time, the tool doesn't allow us to do that. And the argument that I always make too is, even though we may just be looking for text messages, there's other things ancillary to those text messages that we may still want that are related to the text messages. An attachment, for instance, right? Attachment of a picture or a video or a screenshot of a text message, right? That is also a text message, but it's a screenshot of it that is stored in the pictures area of the phone. So when we acquire that data, again, we get as much as the phone will let us have, and then that's phase one. That's all that collection piece. And then phase two is the analysis piece. So if your client or the opposing party is ordered to give over a certain amount of information with regard to, that's relevant to the case, then we'll do an analysis on that data that we get to locate and export anything that may fall within those categories of relevance. Okay, so usually we'll do that. Go ahead. I'm sorry.
But how about like if it's adultery and you don't know if it's text messages, emails, exchanging pictures of each other's back and forth? How do you go out into all that pile of data and determine what is there? And
well, that's a good question. I would say in an adultery case, for instance, first place you want to start is text and pictures, right? Because usually, and I like to say to everyone that I present to, affairs are conducted on these things. So the adultery piece can be kind of a wide net, right? Now, normally the parameters that will be given in an adultery type analysis would be like the dates, right? We have a suspected time when the adultery may have started versus, and usually up until the time of collection or acquisition, and party names, right? So we'll look for those party names, their associated contact information. We may look for information in certain apps that are suspected to be used because there are applications out there that people use to facilitate adultery. All right. Those types of categories would be things that I would drill down on in those types of instances.
Okay. Is it possible that on a phone that you could determine its location? Does the phone store location data, traveling data, that kind of thing?
In many cases, it does. That is somewhat dependent on the user specific settings that they've applied, right? So a lot of applications do store location data natively, but you also have to allow that. So if you think about whenever you install any application on your phone, it's going to ask you for permission for certain things at the time of installation. And so that application will say, hey, I want access to your Bluetooth, your camera, and your location. Well, then we know that application, if you've allowed that application will likely store location information. If you say no, then it shouldn't. I'm not going to say it won't, but it shouldn't. So yeah, depending on what the application is designed to do, number one, and what the permissions are from the user, number two, we may very well be able to help identify location.
And is the memory on the phone that's similar to the memory on a computer, right? If you delete it, it doesn't really delete it. It just erases the title. Underlying bits and bytes are still there, and those can be recovered too?
Potentially. There's a number of different factors that go into that. Number one is the type of storage. If you think about computer forensics years ago, we used to be able to recover a lot of deleted stuff because everything was stored on a spinning hard drive, a hard drive that has a spinning platter and some heads that read it and all that good stuff. And that leaves a lot of remnant data. Nowadays, much of the storage that we deal with, both on computers and certainly on phones, is what we call solid state storage, which is very similar to the storage that's on a thumb drive or something like that, where there's no moving parts.
Right.
Along with that comes the security piece. So let's talk about a phone again. On an iPhone, if you are texting with me and we have a text exchange going for a week, and then I say, you know what, I have no need to text with Randall anymore because our business is concluded, and I delete that text string. I swipe left and delete the entire text string. For a period of time, that data will be recoverable given the proper type of collection. But after that period of time goes by, it will be then sent to the encrypted area of the memory. It's not technically deleted, but it is sent to the encrypted memory of the memory chip that we do not have access to. So it is effectively deleted because we can't recover it.
But it's still on the phone, but it's the encrypted part that Apple puts on the phone then. And
correct.
I'm assuming Apple doesn't give you the access to that.
No, what happens is the encryption keys all get reset when that happens, and so no one has access to it. Ostensibly.
Oh, I see. Okay.
Yeah.
Okay. And then, so what about with cell phones that children have? You hear sort of legendary stories that dad gives the cell phone to the child, and then the child takes it back to mom's house and picks up the audio of mom having an affair or something like that. Is that science fiction? Is something like that possible? Or should a mother reject any electronic gifts from a father?
That's another good question. We actually have a whole CLE that we put on about this. It's called I think my ex is hacking me or something like that. Right. I put it on quite often. And so, we generally get complaints that, especially in domestic matters, that, ex-spouse or estranged spouse is hacking their phone. When in reality, what's really going on in most instances is there was access granted when the relationship was good, right? Think about any parental monitoring app like Life 360 or web, one that tracks the web history on the phone or something like that. When the parents are very amicable, of course, everybody wants to have access to those things so they can monitor what their children are doing. But now the relationship splits up and that access is still there. It's all part of a shared access account. And so that can be kind of turned around into what I call nefarious purposes, right? We can now use that to sort of stalk the opposing party and get information about what they're doing. And some of those apps do incorporate a listening component and certainly a potential of a camera component. Now, it's really hard to turn a camera on a phone on remotely, even with a parental monitoring app. We also have to talk about what the app stores allow. There is technically no such thing as an allowable spyware app on the Apple App Store. Apple does not allow spyware on their app store. However, certain applications like Life 360, for instance, or something like that, could be used to spy on people, even though that's not their primary purpose. So, generally speaking, I just say that if there's a relationship that goes bad and accounts were shared up until that point, then we probably need to cut off that access, that joint access from that point forward. Otherwise, you leave yourself open to some sort of information being eavesdropped or bled or something like that.
Right. And I guess any of the home security systems, a Ring camera, something like that, that maybe the husband set it up and it's just still there functioning and no one thinks anything of it, and just they live their life, and it's visible to someone else. So yeah, that's scary. And then the other major problem that we have is the shared computer, or the joint computer, the family computer. It goes by all different names. So, or the family phone, and here the client shows up and here, everybody uses it. There is no privacy.
Right.
Take everything. I know there's juicy stuff on here. Get it. You're the lawyer. So, and I understand if they sort of wall off parts of the hard drive. So this might be, one parent's business section, and they don't want the kids putting in their dinosaur photographs or whatever. And then maybe another part for mom, and then a part for the kids that maybe that's where the Net Nanny program runs, so they can't go out into the bad parts of the internet. So that's kind of an obvious answer, because it's an action people took to make a private section on their computer. And as I understand, at least in federal law, those areas under your exclusive domain are considered yours, and therefore that would be private. But again, you rarely see that. What you usually see is just everybody is just using it. So does that grant permission for everybody to access it? So where would you go from there if that landed on your desk?
Yeah, that's a great question, and it happens frequently where we get calls. It's similar in that realm, right? We own this phone, right? My wife and I own this phone. She upgraded her phone. She threw this phone in a drawer. Well, now I want you to look at the phone because I pay for the service and all that good stuff, right? So there's a couple of nuances to that, and I've gotten varying feedback from attorneys across the country, because of course we have to not only deal with federal law with it, but we have to consider some of the state laws too. Right. So in those types of instances, I would say that it is the best approach, at least currently that I've been getting, is that we can collect that data, but in order to analyze and report out that data, it's probably best to either have consent or a court order. It's kind of like when I was a cop, and we would say, we had an old saying, when in doubt, get a warrant. I'd say, when in doubt, get a court order. Yeah, but it's an interesting question because, and I have clients clients particularly that don't like it. They say, well, I pay for this service, right? I said, well, you may pay for the service, and you may have even purchased the physical device, but who is the owner of the data that resides within that device, right? It's most likely not the person who's now pulled it out of the desk drawer and giving it to you.
Right.
So we have to be careful with those things. There's a lot of personal information on people's phones, and there's things like the Electronic Communications Privacy Act, which is a little bit in flux now, which is kind of old. But there's also a lot more modern, like state computer trespass laws. Like in Virginia, the computer trespass law may, depending on how you interpret it, may say that I can't even collect that data without a court order. So, it really bears asking those questions. And those are the questions that I ask those attorneys that call me. I said, who actually owns the data? right? I understand there's a difference between the device and the data, at least in my world, because what we don't want, of course, is for someone to turn around and either charge us criminally, certainly not that, or even sue us civilly for violating any of these laws.
Right, right. I know a cautious employer will give you or give the employee lockdown laptop so that the kids can't use it or, things like that. So that's 100% obvious that everything on that computer is, well, I guess the property of the employer and should not have anything that a divorce attorney would be interested on, or else the administrator would catch it. But well, I had the computer and I lost it, or it fell in the river. So now if I'm in a case like that, I generally write a preservation letter. So that kind of tips my hand because I'm putting them on alert that we potentially would demand every gizmo that they have. And so I'm afraid that's where things start getting lost or hammered into dust, or accidentally put in the microwave or something like that. So as I understand the scenario you were just talking about, is that they would take the device before there's even a divorce or before I even make an appearance and take it to you, and then you scan it and keep it, and then we put the device back and you just hold on to it until you get a court order. Is that what I'm understanding you just said?
That's a potential that we could do that. It would depend on the specific circumstances, and again, looking at the law with a little bit more scrutiny. I think, like I say, in Virginia, that I'm not sure if you read the computer trespass law in Virginia that it even allows me to do that. But different states have different laws with regard to that too. So, the guidance sort of shifts depending on where you are and who you're talking to. We just have to be careful, obviously, not to violate any of those things, because that'll not be good for anybody, and it's not good for the evidence, right? It's not good for, ultimately the evidence will be worthless if we violate something like that.
Right, right. And then unfortunately, another atomic bomb that goes off in more and more of these cases is child pornography. That the father or the mother's new boyfriend or the mother's live-in brother or whatever is engaged in something like this, and the proof is right here, and I saw him over his shoulder looking at Japanese schoolgirls or whatever. And the only people that look at Japanese schoolgirls are thus and such. So again, that's like an atomic bomb in the middle of a child custody case. So, but again, if it's there, you'd have to go to court. It takes a few weeks. You'd have to get the person, whoever it is, to turn it over, and then we go on to you to analyze it. That's a lot of time that passes, and a lot of time to delete anything that's bad there. So now I don't understand how child pornography works, but is it stored on different parts of your computer? Is there like a backup section? Even if you delete it, would it still be recoverable? If you don't recover the picture, could you discover the website, which is obviously a child porn website or something like that? And again, the other way around. Like, here's my phone. I do not have child pornography on it. I never did. Scan it. Just, I want you to tell the judge that I'm a good guy. I mean, how would you go about it like that?
Yeah, so it's kind of a proving a negative in
All
those
right.
circumstances, right? And those cases, I like to say, are leave no stone unturned. So we'll look in all of those places. We'll obviously look in the pictures. We'll also look in the deleted area as much as it's accessible to us, given the particular device. We'll look at the web history. We'll look at the search history, because it's not just about web, but searches can be stored in different areas of different devices too. And then essentially just, trying to cover all the bases to make sure that that's not what's happening. Now, what rarely happens, and in fact, I don't know that I've ever had it happen, if not in several years at the very least, is that you actually do find something in those instances. And so the sticky wicket there becomes, what do we do with it, right? Because we are not exempt from the law for possessing it like law enforcement is. So then it becomes, what do you do with it? But yeah, I mean, in those circumstances, in most of the time, in the situation that you laid out, the person being accused of that is so adamant to want to clear their name that they will readily hand over their devices to say, hey, I want you to do an analysis on these devices and prove to the court that there's no such material on there. In very few of them do I see the accusation being thrown out by one party and the other party refusing to turn over their stuff, because it's such an egregious accusation that can have wide ranging ramifications beyond even just divorce and custody, that usually people are very eager to clear that up as much as possible. Unfortunately, also can cost a lot of money.
Yeah, that's what I was just going to say. And then it would be that person's lawyer to ask, that bill be paid, as sanctions and attorney's fees and such by the false accuser. So, but yeah, that's an unfortunate world we live in, that's becoming more, at least commonplace.
Well,
Um,
I don't have to tell you that emotions run high in divorce and custody matters. And so when that happens, I think a lot of rationality goes out the window and people will just throw out all sorts of accusations, not even really knowing what they're saying. I mean, I used to work on the Internet Crimes Against Children Task Force. So the thing about child pornography is, if it looks like a duck and quacks like a duck, it's usually a duck. There's usually not much question about it. So sometimes people's interpretation of what could be defined as that is a little off.
yeah, yeah. And then I guess you have to be careful if the person uses the phone for business, because now you've got all of this business correspondence, and he's involved in whatever, presumably profitable enterprises as his business, and then all of a sudden, all that gets taken, and he doesn't know when the next contract is. I mean, that could be his or her, lifeblood. With how long does something like that take? How long would you actually need the device?
In most cases, we can get the collection done within a day or less. So if you're talking about like a phone or a computer, or even a cloud-based service or like an email server, something like that, we can get it done pretty quickly. And then once we have that, it's an evidence capsule, right? It's a secure evidence file container is what we call it. And then we can essentially do our analysis on that because it's an exact copy of what was on the device.
Okay, so you just take everything off and sift through it later, and then he
Correct.
gets the phone back and is back in business or with his trucking company or whatever it is that he's making the money with. Okay. All right. And then, like I said, then it goes up to the lawyers as to what to do with that and how to present it. So when you give it to the lawyer, is it ready to show to the judge? You provide it with a certification, and that should be enough to put it right into the court record. Is that what
It,
you?
in most instances, yeah. So there's two different ways that we do it, and sometimes both happen, right? So the first way that we'll generally do it is what we would call a tool output. So if I use Celebrite or computer forensic analysis tool or something like that, when we do our analysis, we'll produce whatever is found that is to be of relevance to that analysis or that request. And so that'll be usually an output from the tool. If it's a phone, I'll usually output like a PDF of the text messages or the pictures or whatever for your review. And that's the thing that you would most likely introduce into evidence. We can also do, if it's requested, a formal narrative report, right? So in addition to the tool output, it would be, on this date and time, I got this device from this person, and these were the requests, and these are the methods that I went through, and these are things that I found. And if there's any opinion that has to go into it, we can put it in there as well.
Okay. And then, so then that would the software well, I'm trying to think of challenges. Like, we're not really giving you what's on the phone. You're just turning over what the software said, and I guess the software you're using is well known throughout the trade as a proper tool that doesn't input things, dirty pictures onto it. That those aren't mine. That came from the software. That argument would not fly from the accused party, right?
No. So the way it works is when we get that collection, that secure evidence file container, it is extremely difficult. I won't say impossible because sometimes nothing's impossible, but it's extremely difficult to alter anything about that. Not only that, depending on the medium and depending on how we do things, it is accompanying that secure evidence file container is an algorithmic alphanumeric sequence that is unique to that set of data, right? So if I get the data from your phone, I can run it through this algorithm that will spit out an alphanumeric sequence that is unique to that set of data. So then if someone else comes back behind me, they can run it through the same algorithm and get that same value, right? And that's how we validate it as an accurate representation. If you were to change anything about that data, that numeric value would change. So it would not be the same. So it would be easy. It would be relatively easy to tell that something had changed. So that's kind of like we equate it to a fingerprint, right? It's the fingerprint of the data, or the DNA even of the data. And so when we come up with those alphanumeric calculations, we're able to say, okay, this set of data is equivalent to that set of data. And if we make copies of it, they're all the same and nothing has changed about it.
Mm-hmm. Just for your own information, under Virginia law, they have requests for admissions, and you can request, you have to take the information, whether it's bank statements or tax returns, and send it to the other side with a request that this is authentic, accurate, true, complete, and that whether it's business records, and then they have 21 days to respond. If they do not respond within 21 days, it's admitted, it's evidence, it's authentic, it's admissible to court. If they do respond and deny it, then the way the system is supposed to work is that the other side pays. So they deny it. No, this is not my data. Then the other side is, of course, I have to then prove that it is, and maybe call you in or hopefully do a video deposition or something, and then say, look, here's what you did. Here's the software, the tools you used. This is your standard practice recognized in the field, and the way the request for admissions is, well, I would ask the court to pay for all of this extra verification and extra fees, extra work, extra court reporters, because they did deny it like that. Now, you can't just say, request that you are a bad father. Something like that, it wouldn't work. But again, and if you request the authenticity, admissibility of documents, then that's pretty much, I think, cut and dry within the court system. Like, what do you mean? Why are you saying these aren't your tax returns? What's wrong with what's missing? It's got your name here. It came from your lawyer. So things like that. Why are you making a fight over this? But again, as far as the digital stuff, that's kind of, you're entering a new realm, or a new frontier, I guess, within the court system. But that is of course, you have to have enough time. You have to have 21 days before trial and enough foresight to, I guess, hire you early on to have that ready to go. But that is a really, really simple, easy way to get admissible evidence. And then you could combine it with an interrogatory question that says, well, if you deny any request for admission, why do you deny it? And then they force them to lay out their analysis like that. So the fight that we were just talking about really should not even be necessary if the lawyer, again, you have enough time, and then you can get that 21 days in and request that it be admitted, or the other side has to explain why it's not really what it looks like it is. So, and in my office, we kind of do that just on a regular basis with all the documents that we get in. The wife might get, bank records of the husband, and it's explainable. I mean, it was all around the house, and so admit that these are original bank records. Admit that these are, true, authentic copies. And most of the time, the other lawyer just says, yeah, sure. We're not going to start a fight over something like this because we know we're going to lose. And so that would be, I think, there are some judges like that. They're very, very, they're sort of like the courthouse specialist in technology. And so a lot of the cases would be sent to them on a motion or something like that. You can't send all these cases for trial, of course, to one particular judge. But in terms of making a ruling like that, you might be finding yourself in front of the same judge over and over again, which is nice. I mean, to have that knowledgeable decision is, and of course they want to build the case files and records, and Virginia Lawyers Weekly has always got a little tidbit here and there of some new, well, mainly, I guess, mainly in federal court, but even so, that's where the big money is to pay for that. So
Well, the one place where I've seen an issue with that in the digital realm is with screenshots of text messages.
okay.
So I've seen a lot of courts admit screenshots of text messages and automatically say yes, they're valid because it's a screenshot of a text message. But if we were doing a live demonstration, I could probably show you within about 3 minutes how easy it is to falsify a screenshot of a text message. I mean, I did a CLE for the Virginia Trial Lawyers Association several years ago where I did this whole demonstration about, and it was a text conversation between me and Tom Cruise, and it never happened. Right. So that's one area that I'm consistently hammering home, but we got to get the true authentic evidence is actually a forensic collection off of the phone, because that's the actual text messages, not a screenshot of the text message.
Right, right. There was, you probably might have heard about this case at University of Virginia where a young woman set up a false stalker of herself and then was showing these threatening messages to the guy that she really was romantically interested in, hoping the guy would leap to her defense and they would, become a nice couple. And as far as I can tell, she had no punishment for that whatsoever. It was quite a big scandal, and
Mm-hmm.
the ability to just create and there was conversations back and forth. I mean, the man, the student that she was interested in, was corresponding to the stalker, which of course was relaying back to the girl's phone, and she was sending him replies under the name of this guy. And it was a big scandal because she went to the student the department at the college that protects students from harassment of this nature, and they got involved, and so it was quite a thing. But how do you guard against that? I mean, how do you know? I mean, if it's a Nigerian prince that needs money to restore their African empire, of course, but if it's just somebody that's, I mean, getting to know your teenage children, how do you know if it's legit, if it's real, or you're just under teenage children?
Yeah, it's a good question. I mean, many times you can sort of tell through language, particularly through language, how they phrase things, that it's fake or not. But really, it's hard. I mean, I tell everybody, if you get a spam text message or just a random text message, I get them. For whatever reason, I get them when I travel. Hey, how are you today? And it's from an unknown number. I just, swipe left and ignore and mark as trash, because it's somebody just trying to hit you up for whatever.
But yeah, and the whole grooming thing where I guess all teenagers are somewhat troubled in some way or shape or form. Is it the other side of the divorce? Is it the mother's new boyfriend going after the daughter? I mean, just, then having the ability to track that down, because that's what the clients come to me with. This is happening. And it's like, okay, but I need a lot more detail, built into that. Tell me how, how would we ever prove it? When did this come? Whose phone sent it? Do you recognize the email address? And you just have to sit down. Whose phone is it? Well, it's my husband's phone, but he gave it to me. I've heard that a number of times. So therefore, he gave it to me, and I have permission to use it. So I can read his text messages. Or it's a tangled knot. It really is.
Yeah.
And none of this is obvious. Especially you're sitting there in your conference room and the client's right in front of you. And you're like, I don't know.
Yeah. Well, and a lot of those things, there can be, and there often is, a paper trail associated with them, false accounts or catfish type accounts, those types of things. The issue becomes, number one, time, like you were mentioning previously. Number two, the cost involved with trying to track all that down. I mean, you can issue a series of subpoenas through the litigation process to try to track those things down. There's cost, of course, associated with that, and it can often be a rabbit hole. Also, sometimes they'll just ignore your subpoena. I know in most civil cases where people talk about subpoenaing, like Facebook, for instance, Facebook will just ignore the civil subpoena. I mean, they have over 1 billion subscribers. So if they reply to every civil subpoena they got, that's all they'd be doing all day long. So again, it gets to be can you do it? Yes, technically you can, but will they reply, and how much money do you want to put into figuring these things out?
Both for you and for your lawyer going to court, forcing Facebook to reply.
Right.
How much is that going to cost, and how long is it going to take? And do you have enough time in the 1 year from when you filed to get this information from
Right.
Facebook with their lawyers and their delaying tactics? One thing I went through your listing here, and I did want to ask you about, what is a historical cell site location information analysis?
So everyone's cell phone is connected to a cell site while it's on, and the cellular companies log that information about usage events and keep that information for a certain period of time. So the law enforcement initially got into this, and now I've used it multiple times in the civil realm. In fact, we work about a lot of insurance cases where we use it too, where we can either through consent or court order get data from the cellular provider that says Randall's cell phone was connected to this cell site, not only this cell site at a latitude and longitude, but also a direction off of that cell site for this phone call or text message or data transmission at a particular date and time. So using those records to put someone, or rather someone's device, in a general geographic location at a particular time can often be very useful in an investigation and in litigation. So the cops do it all the time with fugitives, with murder suspects, things like that. Again, we use it sometimes. I've used it in domestic cases to prove cohabitation because, obviously in the evening hours, if someone is cohabitating with an ex-spouse or something like that, well, their phone is most likely going to be connecting to that same cell site. Let's say between the hours of 6 or 7 p.m. and 7 a.m. Right. And sometimes those cases are very high dollar cases. I worked one in New Jersey where our client was shelling out $10,000 a month in alimony. And if he could prove that there was cohabitation going on, then that would get cut off. So, it does have application kind of across the board, but I love it because it's pure evidence. It's evidence that the user does not have any access to. And even if they did have access to it, it's not like they could change it. It's stored with the cellular provider and then provided through either, like I say, either consent or in the litigation process.
So the husband is paying the spouse support. So you would go to the cell tower nearest to the ex-wife's house and get everything off of that cell tower or ping point, whatever you call it. Is that the way? And you would want to see if well, no, I guess it wouldn't be the house. It would be, well, maybe someone was living with the ex-wife. Cohabitation would be that way. But then you need to know his cell phone number.
Yes.
See if he was in the house making phone calls morning, noon, and night, 7 days a week to prove that he was obviously living there. And you would know the date and the time of each one. But for that, you need to know his cell phone number.
Yes, that's usually relatively easy to find out. Yeah, so we would say, let's say his cell phone number is a Verizon cell phone number. We'd go to Verizon and say, hey, we want. Usually it's 6 months or a year is what I've seen in most cohabitation type things. We want a year's worth of records for this person as well as their subscriber information, because their subscriber information will have their actual home address or their technical home address. And so we can then look at that year's worth of records and do essentially a pattern analysis of when they're using a cell site or cell sites that could be associated with that residence of the ex-wife to help prove that cohabitation. Now, of course, we want to get other pertinent locations, number one, his listed address, number two, his work address, and any, if he has kids or whatever, their addresses, those types of things. So there's a lot of pattern analysis that goes into it too. But it's very powerful data. Years ago, somebody somewhere along the way called it junk science. It's not really junk science because, again, it's pure evidence. It's the records indicate that somebody connected to a cell site at a latitude and longitude that logged with the FCC. It's not like that's up for debate. And then a connection off of that cell site in a particular direction. So it's really just a matter of getting the records and the appropriate interpretation of the records.
And you could also tell if they were both going to their out-of-state mountain cabin on the first Tuesday of every month, even on the as a possibility, but that these two were meeting there on a regular basis just from the cell phone records.
Correct. Yeah. And of course, in that case, we'd also probably want to get her cell phone records too, to see where they're, no pun intended, where they're married up.
Exactly right. Interesting. Because one of the myths in divorce is if you think you're being followed, you would want to, okay, I think we're out of time here. Wow, I could go on. I got a lot more questions for you. So overall, the best thing to do is to hire you early in a case.
I would say that in almost any case, even if you're not gonna use the services, the having the consultant on staff on the team early on is a great approach.
Okay, very good. All right, well, thank you very much for being here, and really appreciate it.
Thanks for having me, Randall. I appreciate it.